I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. Our rates are based on your income, so the less you make, the less you have to pay. Today, we're going to be discussing the charge of larceny in Massachusetts. What is larceny? Well, larceny is a theft crime. You're accused of taking something from somebody else. In fact, the elements that must be proven on this particular case, there are three. The first is that you took and carried away. Number two is that it was the personal property of another. And three, that you did so with the intent to permanently deprive the owner of their property. Okay, so those three things must be proven by the Commonwealth in order to find you guilty. They must be proven beyond a reasonable doubt. So what is larceny? As I said, it's a theft crime. You're accused of stealing something from somebody else. And larceny can be a felony or a misdemeanor, depending on a number of factors. In fact, some of those factors are you look to see what was stolen, how it was stolen, from where was it stolen, and what was the value of the item or items that were allegedly stolen. So we already went through the elements that have to be proven. So let's take a look at each of them a little bit more closely. What is taking and carrying away? That's the first element. The taking and carrying away is physically transferring that property from another person to you. And it doesn't matter if the transfer involves only a slight movement or if it lasts for only a short period of time. So you can take something from someone for a period of time, and that is taking and carrying away that particular item. What is property in Massachusetts? Well, property in this case means personal property as opposed to real estate. Personal property basically is anything that you can think of that you own, any item that you own. It could be money, personal items, bank notes, and even domesticated animals. In Massachusetts, the statute includes domesticated animals. So you can steal somebody else's dog, somebody else's cat, their cow, their goat, their chicken, whatever it might be, and that can qualify as property of another. That's what is property. And when proving property of another, the Commonwealth doesn't have to prove who owns the property. They don't have to have a particular person to come in and say, yes, that's my property. All they have to prove is that it's not yours, that somebody else is the owner, and they don't even have to know exactly who the owner is in order to convict you of this particular crime. Let's see, what does it mean to intend to permanently deprive the person of that item? So clearly, if you take something and you're hiding it away, that's going to be seen as the intent to permanently deprive that person of their property. Of course, a jury can't look into your mind to see what your intent was on this charge or on any particular charge. But they look to the facts and circumstances, your words, your deeds, and things along those lines. It can also be if you took somebody's property and you abandoned it somewhere, so the owner was never going to recover it. So you don't have to maintain control or possession over that property, as long as you took it with the intent to permanently deprive. As I say, if the property was abandoned. So let's just say you take somebody's car. Well, that's a different case. But let's say you take somebody's laptop computer. You take it for a while, and then you throw it in the woods, and you're not going to use it again. But the original owner can't have it either. That's intent to permanently deprive. One of the main factors is in determining whether it's going to be charged as a misdemeanor or as a felony is the value of the item or items that were stolen. If the value is under $1,200, it is charged as a misdemeanor. If it's over $1,200, the charge will be filed as a felony. And the penalties are higher for a felony, and having a conviction of a felony on your record will cause you even more trouble than if you have a conviction on a misdemeanor, which is plenty of problems all on its own. One of the things that sometimes happen is we argue over the value of a particular item. In one particular instance, if there are several things that are stolen over a period of time, Are they each individual cases of misdemeanors? Let's say items are stolen that cost $200, and the person does that 7 times, so that's going to put you over the limit in total. But each of those 7 times would be a misdemeanor because each of those items is below the $1,200 limit. Well, the Supreme Judicial Court in Massachusetts has come down saying if the larceny is part of a single scheme, and each of those items, even if they were taken on different dates or something, if it's can be proven that it's a single scheme, the Commonwealth can combine the value of each of those items to create a felony charge rather than a misdemeanor charge. One of the defenses to a larceny charge is what they call a claim of right. So what that means is that if you truthfully believe that you had a claim of right to those items, so that you had the right to take those items from whoever that person is, you can use that as a defense in your larceny case. If you have a legal right to those objects, you can take them without causing any violence or anything along those lines. Now, even if you're mistaken, you can still be protected under this defense, because what happens is, for instance, there was a case where a woman was mugged on the street. There were 2 individuals that she claims mugged them. She said, oh, they're in a car, they're down the road. These 2 gentlemen happened by just afterwards. She told them about that. They took off. They found 2 individuals that fit basically the description. They grabbed the what they thought the items were, credit cards in this instance, and some other things, some other personal items, to return those to the original victim. As it turns out, those individuals did not have the victim's credit cards and personal items. They were taken by mistake by these other 2 gentlemen. The second pair of gentlemen who took the items were charged with larceny because they took the personal property of another with the intent to permanently deprive it. But they had this claim of right defense saying, basically, hey, look, she told us that some guys who looked like these guys took her stuff. We went to get it back for her. We were mistaken, but we had a legitimate claim of right, and the court found out that ruled that in fact they agreed with that defense, and they were not convicted of that crime. So as I said, the penalty, the cutoff is $1,200. The value of the items, if it's a felony, it can carry up to 5 years in a state prison with a $25,000 fine. If it's a misdemeanor, the maximum penalty is 1 year in the House of Corrections with a $1,500 fine. So keep that in mind. Larceny charges are very common. There are other aggregating factors, such as if it was taken off a person or if it was taken from a building and so forth. But this is sort of the straight garden variety larceny case that we often see in the district courts in Massachusetts. If you have any other questions, please feel free to visit us at affordlaw.org. As I say, we represent criminal and family law clients throughout Massachusetts, and our fees are on a sliding scale. Those fees are based on your income, so that means that the less you make, the less you have to pay. Please, again, visit us at affordlaw.org. We have answers to your frequently asked questions, and while you're there, feel free to book a free virtual appointment with me. I'd be happy to answer any questions, any specific questions you have about larceny charges or any other criminal or family law matters in Massachusetts. At Afford Law, we're making justice affordable. Thank you.